The question is the bill be agreed to in principle. Ms Lauder.
Thank you, Madam Deputy Speaker. Pleased today to rise to speak about the Planning, Building and Environment Legislation Amendment Bill 2017. This is the second PABLAB that's been brought to the Assembly this year, and it's an omnibus bill that enables comparatively minor matters to be dealt with expediently and consolidates amendments into one place, with the intention of making the amendment process more user-friendly and accessible. Note there, Madam Speaker, the use of the word intention. The bill proposes minor policy amendments to the Energy Efficiency Cost of Living Improvement Act 2012, the Nature Conservation Act 2014, and the bill also proposes a number of technical and editorial amendments to the following legislation: the Climate Change and Greenhouse Gas Reduction Act 2010, the Electricity Feed-in Large-Scale Renewable Energy Generation Act 2011, the Electricity Feed-in Renewable Energy Premium Act 2008, the Environment Protection Act 1997, the Heritage Act 2004, the Nature Conservation Act 2014, the Planning and Development Act 2007, the Public Place Names Act 1989, the Water Resources Act 2007, and the Water Resources Regulation 2007. I'll briefly run through some of the changes, Madam Deputy Speaker. Part 2, the Climate Change and Greenhouse Gas Reduction Act 2010. This creates a mechanism for the Minister to table the Climate Council's annual report when the report is published during an election period. Part 3, Electricity Feed-in Large-Scale Renewable Energy Generation Act 2011. It amends the definition of the Australian Capital Region to include the ACT and areas defined in regulation. This is because New South Wales Council mergers have led to some name changes. These councils with name changes are listed in the regulation and appear to cover the same areas. Part 4, the Electricity Feed-in Renewable Energy Premium Act 2008, correcting the legislation to refer to the Utilities Technical Regulation Act rather than the Utilities Act. Part 5, Energy Efficiency Cost of Living Improvement Act 2012, amending the power of the administrator under the Energy Efficiency Cost of Living Improvement Act to allow for easier sharing of compliance information with similar environmental and greenhouse gas emissions agencies in other jurisdictions. Part 6, the Environmental Protection Act, increases the prerequisites and conditions needed in a notice requiring an environmental audit on contaminated land to be in line with other audits the authority may demand. Also creates an offence for failing to comply with a notice to audit contaminated land, similar to failure to conduct another audit. And Part 7, the Heritage Act 2004. This clause amends the provision to state that the Council must provide its reasons for a decision, but removes the requirement that the Council provides an assessment against the criteria if there has not been one. And I'll speak more about the changes to the Heritage Act later, Madam Deputy Speaker. Part 8, the Nature Conservation Act 2014, changes the reporting period from 5 to 7 years, the justification being to bring it in line with minimum federal reporting. Part 9, Planning and Development Act 2007, the change adds the EPA as a person who must be consulted by the custodian in the preparation of a draft management plan for an area of public land. Part 10, Public Place Names Act 1989. The current Act outlines that all cultural groups named in the regulations are to be consulted on public place names. The current regulations name ATSIC as the only cultural group. However, this is no longer in existence, so the bill has been changed to direct the Minister to take reasonable steps to consult an appropriate cultural group. Again, Madam Deputy Speaker, I'll speak a little more about the Public Place Names Act a bit later. Part 11, the Water Resources Act. The Act is being amended to more accurately reflect by geography the current councils within the water catchment region areas as a consequence of the changed names of several New South Wales councils. Also acknowledges and specifies a pre-election period for tabling reports which have been presented to the Minister during an election campaign. It also changes the ACT government membership to better reflect the directorates involved, refines membership, coordination group from several heads of directorates to the heads of service plus an appropriate Director General. Part 12, the Water Resources Regulation 2007, prescribes the councils which must be negotiated with, accommodating current and possible future council amalgamations and name changes, appoints the same heads of directorates which were named in the Act to the coordination group. And Madam Speaker, as a whole, the Canberra Liberals support this bill. There are, however, two sections that we do not agree with: the changes to the Heritage Act and the changes to the Public Place Names Act. And I'll speak to those concerns in a moment. But first, I'm disappointed to have to mention once again the importance of consultation. It's quite obvious to just about any person on the street that good policy is derived when governments do good consultation. And this government has not adequately consulted with the community on this bill because they feel these changes are minor in nature. The government's good at talking the talk when it comes to consultation, but they don't walk the walk. They talk about a lot of grand plans about new ways to consult, Madam Deputy Speaker, spending more money on community consultation initiatives such as participatory democracy and community juries. But I don't believe, Madam Deputy Speaker, the issue is the style of the consultation. It's actually the fact of doing any consultation. The government doesn't bother to consult on many of these issues. They can't get the basics right. Not only did the government fail to consult with community on this particular bill, they also made it very difficult for my office to consult, as emails were ignored and phone calls not returned until very late in the piece. Remember, Madam Deputy Speaker, this bill was set down for debate last sitting period. My office approached the Minister's office on the 23rd of March asking for a briefing on this bill. After 10 emails and 5 phone calls, 6 weeks later, a briefing was finally arrived for the Monday before this bill was originally due to come to the Assembly last sitting. Since the last sitting, when the bill wasn't debated until now, my office reached out again asking more questions. Again, my office and the community has been left waiting. Questions which were only answered after 5 p.m. last night. If my office is having this much difficulty to get any engagement from the Minister, you have to question how are members of the general community and community groups getting on trying to consult. Madam Speaker, unintended consequences are avoided through consultation, through gathering the views of many, many different interested parties. And the response I've had from the Minister's office is that this amendment to the Heritage Act is proposed to fix a drafting error that came about through the introduction of a clause back in May last year to address a gap in legislation at the time of what information must be included. So each time something is introduced, it has the possibility of introducing another problem. And by not looking at all the possible permutations and combinations and allowing different people to view what's being proposed, the chances of making a mistake, small, inadvertent, accidental, unintended, but a mistake nevertheless, is greater than if you allow interested parties to participate in the process. So, Madam Deputy Speaker, the amendments that I'll put up in the substantive part of this debate are a result of consultation with the community and those who do have extensive experience in the policy areas, those who can see the possibility of unintended consequences of these changes proposed today. Every community group my office and I spoke to was unaware the government were making these changes before last sitting period. Every community group was outraged. It was not the role of the opposition to do the government's consultation for them, but here we are consulting with community groups and trying to make a change that will make this change better for the community. Madam Deputy Speaker, of the people that I spoke to about these changes, I received a number of emails, including the Inner South Community Council, the National Trust, again, a number of different organisations that I have here, representatives of other community councils as well, who all said they were unaware of the proposed changes. This is what consultation looks like, Madam Deputy Speaker, a range of emails from a range of different organisations.
I hope that isn't a prop, Ms Lauder.
No, I can table them if you like. They're here for my own reference.
Great.
So this is how we could avoid unintended consequences of proposed amendments while still respecting the changes that the government believe are necessary. But it's a way to think through the possible things that could go wrong. And in one of these, I'll quote Madam Deputy Speaker, "The proposed amendments have generated much anxiety, with significant time and effort extended by the National Trust, community councils and other community organisations considering the proposed amendment and its implications." And this particular letter goes on to say, Madam Deputy Speaker, "We need more proactive engagement of key stakeholders by the ACT government when such legislative amendments are proposed." So it's not just me saying this is necessary. I'm trying to put forward the views of a number of different community groups in relation to the changes proposed by the Minister in this PABLAB, which is intended to be minor technical and policy changes, but in some cases has those unintended consequences. So, Madam Deputy Speaker, I move the amendments. No, I'll do that a bit later. I'll speak now a little bit about some of the amendments that I will be moving later. The Heritage Act. Section 34 of the Heritage Act deals with notice of a decision of registration, and the government's proposed change will remove the requirement for an assessment to the heritage significance criteria. The explanatory statement says that there are some circumstances where an assessment is not undertaken because a decision not to provisionally register a place or object is made on another basis. The explanatory statement then gives, as an example, a situation where, quote, "a place has natural heritage significance and is more appropriately protected under the Nature Conservation Act 2014, end quote. And in that situation, the government claims the council should not be required to provide an assessment against the heritage significance criteria. However, the unintended consequence of this change could see an application simply refused on any grounds. For example, the council could consider that registration would interfere with the development potential of the place and so refuse an application for heritage registration on this ground. In other words, if no heritage assessment has been done, the council could simply refuse the application without ever having even thought about the heritage significance of the place or object. And whilst I don't believe that the changes are intended to allow this to happen, the proposed legislation leaves it open, in the view of members of community organisations, including the National Trust, leaves it open to such interpretation. The National Trust has said about the issue, I'll quote, "The National Trust and the view of the heritage practitioners and community members that I've been in contact with is greatly concerned that the proposed amendments will enable the ACT Heritage Council to make decisions without adequate assessment and advice as to why they reached the decision. Due process requires an open advice discussion on why heritage listings are made or not made, as this is the only way of informing the community of what is our heritage and why. We support the proposals by the opposition today as they retained the original clause but did enable some latitude for items that are covered by other territory acts. For this reason, Madam Deputy Speaker, we're proposing an amendment to this section today. The amendment we'll propose will deal with the situation outlined in the explanatory statement while allowing for the decision-making requirements of the Heritage Council. Our amendment leaves the current legislation intact and provides that the heritage assessment doesn't have to be undertaken if the place or object is protected under another territory law or if the application is incomplete. These changes are made in section 29 and in section 32. If an application is incomplete, the change that we're proposing allows for the council to make a decision at the appropriate time of nomination application being received. In regards to if a place or object is protected under another territory law, our proposed changes allows the council to make the determination about provisional registration at the provisional registration stage, not an assessment stage. The government's proposed amendment goes way beyond what's required to solve the issue that was outlined in the explanatory statement and in the briefing we received from the government. While we'd rather that no changes be made, we're proposing the amendment as an alternative to solve the issue the government has identified, but it limits, we believe, the unintended consequences that community and heritage practitioners have foreseen. The amendment comes after considerable consultation with the heritage community, including but not limited to the Lake Burley Griffin Guardians, the National Trust and many different community councils and a number of individuals. I'd like to thank each and every one of them for their assistance, and I hope they've felt heard in this process and listened to. And I'll continue to consult and communicate with the community, even if this government won't. With regards to the Public Place Names Act, Madam Deputy Speaker, we're moving a change to Section 4 of the Public Place Names Act. The government proposed to change the requirements that the minister consult with prescribed entities in relation to public place names that use terms from Aboriginal and Torres Strait Islander languages, because the current prescribed entity, ATSIC, no longer exists. However, the changes this bill proposes goes too far and only requires the minister to take reasonable steps. Reasonable steps is something that's very, very difficult to find a definition of, especially in the Australian context. There is an example from the UK, in Crown Croydon Property Forum Limited versus London Borough of Croydon in 2015, which talks about reasonable steps to consult. But, Madam Deputy Speaker, it's a high threshold for a claimant challenging a consultation process to reach. I wonder if that's the definition that the government wants. Maybe the government is considering that reasonable steps to consult are much of a muchness with reasonable skill and knowledge, which there is an Australian definition for under Australian Securities Commission versus Gallagher in 1994. But if it's this government's intention of what reasonable steps under the Public Place Names Act means, the minister must act in a way which an ordinarily prudent person with the same skill, knowledge and experience as the minister would when taking steps to engage with Indigenous organisation. It's a difficult definition to fulfil. It leaves considerable onus and expensive interpretation up to the courts. I had a briefing from the minister's office eventually on this matter, but his staff couldn't adequately define the minister's meaning of what reasonable steps might actually entail, and that's why we're proposing an amendment to this section. It retains the requirement for the minister to consult with an appropriate organisation that represents the interests of Aboriginal and Torres Strait Islanders. It allows the minister to update the regulations with multiple different cultural groups without the need to consult each of them on every issue, but it does allow for broad consultation with multiple groups and allows the minister to seek the advice of the most appropriate group without placing it under an unfair administrative burden. So in the past month, or just yesterday, we discussed in the Assembly the lack of consultation and communication from the government and confusing communication in relation to the Bush Healing Farm and other Indigenous community groups involved in the Bush Healing Farm. The government's proposed amendment to the Public Place Name Act will water down the requirements of further consultation and could lead to further difficulties. I'll speak a little more in the detail stage about this change. So, Madam Speaker, as I started by saying, the majority of this bill the Canberra Liberals support. Of 26 clauses, we're proposing amendments to only 2. These amendments have come about from consultation with the community, which is something that